Okay, welcome everyone. I hope you can hear us okay. Thank you for joining us for today's webinar. My name is Beth Cohen-King, and I'm the Marketing Director at Margolis & Bloom. Margolis & Bloom works with its clients to find the best estate planning or elder law solution for each client's unique situation and goals. We bring to this effort 30 years of experience and a commitment to providing the highest level of personalized service. So for today's presentation, Harry Margolis is going to be presenting on understanding incapacity and undue influence and ways to ensure legal protection. If you do have any questions during the presentation, we welcome them, but please type them into the question box in your control panel on the right side of your computer, and we will have time for questions at the end. So I want to turn it over to our presenter, Harry, and you can take it away.
Okay, thank you, Beth. So, great topics today, at least for the elder law practitioner, incapacity and undue influence. And so we're going to talk about both of these issues, which are related but different, but they often get confused, and we'll explain the relationship. So I'm going to talk about the standards for capacity, best practices for attorneys in dealing with that issue, then really do the same thing for undue influence, talk about the standards, red flags, and what lawyers can do to protect against undue influence and what we can't do, unfortunately. And then we will, I'll answer any questions you have. And that should probably take our 45 minutes. If we finish early, we finish early. If we have too many questions, we'll answer them afterwards online. So let's get to the. So, as I said, incapacity and undue influence are different but related. I'm going to start with a story, which may be a little bit of both. I had a call recently by the sister of a man who's 72 years old, has early dementia, and last fall he got married. And so there's certainly a question whether he had capacity to get married. And since he got married, he moved in with his wife, and they have a financial agreement where he pays her $1,000 a month towards room and board. Because of this extra income, his new wife has been able to retire. And the person who called me was the man's sister, who's wary of the whole situation, given that her brother seems to have been hijacked by this new woman. But she's also not sure if there's really a problem, since it's also clear that this new wife is taking care of her brother, which is maybe a good thing. He'll be able to live, at least in her home, longer. But their biggest issue is that she's not very disclosing of the new wife of what's going on in financial issues. So they don't know if she's really what's going on and how suspicious they should be and what measures they can take. But this is, certainly there's an issue of capacity here because the man has dementia, and there's potentially an issue of undue influence because this new person has come into his life at a time when he may not have the capacity to make independent judgments on his own. So that kind of situation is not that unusual. And so as we go through capacity, I'm going to talk about the fact that there are different levels of capacity depending on what you're doing. So for some things, you need a higher or lower level of capacity, and there's no bright line. It's not like you have capacity today and you don't tomorrow. Anyone who has some dementia is going through it's progressive, and even they may do better at certain times of the day than others. So it's a somewhat of a murky issue given the issue of just the cognitive ability, the issue of what kind of document you're signing, and the issue of what kind of situation is it. What are you trying to do? Who's in the picture? How much transparency is there? So the first question is, what is the rule for what's called testamentary capacity? And that is the capacity to sign a will. And this, and the person who signed the will is called the testator, and they have to understand and carry in mind, kind of a judicial term, in a general way, the nature and situation of the property and the relations to those persons would naturally have some claim to his remembrance. I believe this language is actually from a case. And so you have to execute a will, you need to know who you want to benefit, know who your family is, assuming that's who you want to benefit, and have a general idea of what your property is. And so that is actually a relatively low barrier compared to some other items. And for instance, contractual capacity, so that's the capacity to enter into a contract, is a higher standard, and this is language from a 1989 case. Competence to enter into a contract, I think that should be presupposes something more than a transient surge of lucidity. So for a will, people talk about having lucidity at a moment where you understand your family, you understand in a general way your property, and you can write a will. In this court is saying that's not enough for a contract. It involves not merely comprehension of what is going on, but an ability to comprehend the nature and quality of the consequences. From a testator, we ask awareness of the natural objects of bounty. The choice among those objects may be seen by others as arbitrary, but arbitrariness or capriciousness may be allowed a donor. In the act of entering into a contract, there are reciprocal obligations, and it is appropriate when mental incapacity, as here is manifest, to require a baseline of reasonableness. So you can be unreasonable in your will, but not in your contract. So then there's durable power of attorney, which has a mix of both contract and will in it. I mean, it's a contract because you're contracting with your agent to carry out your wishes, but they're often doing things more. They may be making gifts. They may be managing your assets in a way that may be in a way more like a will. I always feel that power of attorney does not need as high a standard where there's no conflict. So if the idea is you're going to appoint your spouse or child to manage your affairs for you, and you trust them, and you know who they are, that's probably enough. You don't necessarily need to understand what your assets are anymore, or certainly have understanding of the types of things that like contracts that the person you're naming, the agent, might carry out for you. So I think it's in most cases it's a lower standard than either a contract or a will, but I'm saying in most cases where there's no question about who to appoint, sometimes conflicts arise, and when there's conflicts arise, which is where we get into kind of situational capacity, then you are going to look for a higher standard for a number of reasons. Number one, so if you have warring kids and you're trying to choose who you're going to name on your power of attorney, then I think you're going to want to make sure that the person has a higher level of capacity and knows what they're doing, because number one, their capacity may be challenged, and you want to be able to defend the choices they made. And number two, it's not just like they're appointing somebody because everybody agrees that's the best person in the family to handle the finances. And so you're not just facilitating an easy way to get things done. Instead, you're trying to protect your client and protect, usually the old elder person, and they really need to know who they want to appoint if that may be challenged, or if not challenged, at least questioned. So that's where we get into situational capacity. Whenever you're a lawyer working with clients and there's a question about capacity, you're thinking, well, is this going to be challenged? And if it's going to be challenged, you want to be in a better situation to protect the client if there is a challenge. So how can you be in a better situation? to know that the person has capacity, and this also to some extent relates to undue influence, to know that they're not under undue influence, and to be able to protect the document if needed. So first, you have to meet with the client alone. If there's any question, you got to meet with the client alone so you have some idea if they're whether they can answer questions, have a discussion, not simply parroting and nodding to what somebody else says they think they want. Ask open questions. They should not be yes or no questions because clients can nod, shake their head, more often nod in agreement if you provide leading questions. Like, for instance, don't say, is it okay to name your son Jack on your durable power of attorney? Because they may just say, okay. And if you had asked them if it's okay to name your daughter Sally on the power of attorney, they might have nodded their head and said okay to that as well. But if you ask, who do you want to name, that's not an open question and they have to choose. So that's that's important. And then spend as much time as you can with the client, because often people can sort of fake it, can get by for a short conversation, but the longer you're together, the deeper your conversation, the more likely you're going to become aware of incapacity if it exists. So an interesting thing is, well, what do you do? So you determine that the client's capacity is not so clear, might be challenged. Do you then not do anything? Do you say, well, I can't help you because you're incapacitated, even though you clearly are stating what you want, that you want to give your assets to one child and not another, or something like that? And the rule and the guidelines in that case are might be a little surprising. So if clearly the person doesn't know what they want and can't form a judgment of what they want, then you can't go ahead. But where they can, and there's still an issue of incapacity, then your job is to represent them to carry out their wishes. As a lawyer, your job is to represent them and carry out their wishes to the best of your ability and to proceed, and it's up to the court actually to determine whether, assuming there's a challenge, it's up to the court to determine whether there's incapacity. So, and this is the standard of the American College of Trust and Estate Counsel, ACTEC. The lawyer generally should not prepare a will, trust agreement, or other dispositive instrument for a client whom the lawyer reasonably believes lacks the requisite capacity. On the other hand, because of the importance of testamentary freedom, the lawyer may properly assist clients whose testamentary capacity appears to be borderline. In any such case, the lawyer should take steps to preserve evidence regarding the client's testamentary capacity. And then if anybody questions it, the evidence is there, one way or the other. So that's capacity, and as you'll see in a second, it relates to undue influence. And the main reason is that if you have if you have a decline in cognitive ability, then you're more likely to be subject to undue influence. So there are four elements to undue influence. First, the estate plan involves an unnatural disposition of the estate. So if you're giving your estate to your new spouse or to your caregiver or somebody that's considered quote unquote unnatural in terms of who ought to get your estate, then that raises a flag. It has to be, and you have to meet all four of these. So it's estate plan involves an unnatural disposition of the estate by a person who is susceptible to undue influence. That's the incapacity part. To the advantage of someone who has the opportunity to exercise undue influence. So again, the caregiver, the new spouse, they're with the person all the time, and so they have the opportunity to exercise undue influence, and then in fact uses that opportunity to procure favorable disposition of the client's estate plan. So these are the red flags: potential incapacity, Opportunity for undue influence, an unusual distribution. Haste is often a flag. This has got to be done tomorrow. What's the rush in most cases? Disagreement. If there's a disagreement between family members or between family members and non-family members, that's a red flag. And a huge red flag is when it's not the client who calls you, it's somebody else who says, my dad wants to redo his estate plan and here's what he wants to do. Your antenna got to start waving, and you got to be really careful in those situations. So there was a pretty big case in Boston a few years ago, a story of an elderly woman with a $10 million estate. She apparently had no estate plan. She's in the hospital awaiting surgery. She has a longtime financial planner who goes to visit her, and she says she's ready before she has the surgery to execute a will. Financial planner calls an estate planner, and because of the rush, the estate planner, rather than going to see the woman, because it wasn't on schedule, he couldn't just drop everything, asked the financial planner to go back and interview the client to see what she wanted. So the financial planner does that, and he reports back the client's wishes, including that she wanted to give the financial planner $2 million. So the attorney drafts the plan and goes to see the client with the documents all ready to be signed. And the client, he meets with her, the client confirms that this is what she wants. She signs the documents, the financial planner is in the room the whole time, and the woman dies. And then, of course, all hell breaks out because she favored some members of her family more than others. And a number of large law firms in Boston got involved and were well paid litigating this matter. So, what should well, first, what was there undue influence here? And let's look at some of the factors. Potential incapacity. I think the attorney testified that he talked to her and didn't feel there were any issues of incapacity. Opportunity. Well, certainly the financial planner was meeting with her alone and had a long-term relationship with her. Perhaps there was an opportunity for undue influence. Unusual distribution. Certainly giving your financial planner $2 million is unusual. Haste. There's definitely haste here, which is why the lawyer delegated the financial planner to do the interview. And of course the financial planner was the intermediary. So a lot of grounds, at least to bring this to court and challenge the distribution and challenge the validity of the will. So what should the lawyer have done? Well, certainly it would have been a lot better if the lawyer had met with the client alone. Number two, if the lawyer had met with the client and gotten gotten her guidance on what she wanted rather than the financial planner. Of course, the lawyer, when he got the call and heard about the schedule and how fast everything had to be done, might not have been able to do that, which is why he relied on the financial planner. But it would have been a lot better. And in most cases, in terms of protective measures any lawyer should take is meet with the client alone, meet with a client at least twice, so that you see them in at different times, and see if they're consistent in what they want and if they seem to have capacity both times. And a potential home visit, and I say this doesn't really apply as much to hospital visit, but when a client comes into our offices, we're only seeing them for a short period of time in the setting of our office, and if there is any kind of questions about whether there's undue influence, it may be good to see what actually is going on in the home, whether kind of how under the thumb of a caregiver or somebody else the client may be. So those are a few ways to try to avoid undue influence and assess whether it's occurring, as well as assessing capacity. So these steps make it less likely that undue influence will occur, but unfortunately they're not foolproof because we really we don't spend enough time with our clients to know for sure what's really going on behind the scenes. And as we discussed before, there's always a conflict between doing nothing in order to protect the client and doing nothing to help the client further the client's goals. And there's the other issue of if you say, well, this situation really makes me uncomfortable due to the diagnosis, what you want to do with your estate, the fact that you're favoring some people and not others, and that this is different from, especially if it's different from what they wanted to do in the past, and you say, no, I'm not going to do this. It's problematic because so the person then just goes to another lawyer, and maybe they do it, and it doesn't necessarily protect the client and protect the estate. On the one hand. On the other, just putting up roadblocks may prevent anything from happening, especially from anything happening too fast. Going back to the case I was telling you about, the woman, I'm not sure what I said, but the woman went to surgery and then she died, and so that's why there was litigation. But if the lawyer had said, I'm really totally uncomfortable with this situation and I can't proceed, let's talk about it after your surgery, the woman's wishes would not have been put into effect because her estate would have just gone through the laws of intestacy to her closest relatives, including she had two brothers, and one of whom she didn't want to give anything to. And this came out in the course of litigation. They found out that she had done another will back, I think I forget the year, 1980 or something like that. They located the will, and again, she had disinherited this one brother. So that was clearly a long-standing wish that might not have been put into effect if the lawyer had not acted, even though the way the lawyer did act led to litigation. So that's really the story with incapacity and undue influence. It's an issue of on incapacity. It's a variable standard depending on the document, and the situation, and you just have to be very sensitive to the person, engage them in a way that you can assess their capacity. Now, let me add one more thing about this. People talk a lot about whether capacity is a medical issue or a legal issue. So should you go, if there's an issue of capacity, should you go and ask the doctor or the psychologist whether the client has capacity? And my feeling is that that's not very helpful because the doctor may be able to tell you about a diagnosis, may be able to tell you symptoms, but they, number one, probably don't know the standard for capacity for different kinds of documents, and so that's a big issue. And they're not in the room with the lawyer trying to determine whether the client has capacity, and so won't be able to testify as to what's going on at the moment that they executed the documents. So that can be useful. It's certainly, I think it's as a positive thing if you have a case where you expect the capacity to be challenged and you can show that the doctor said the person does have capacity to understand things. That's certainly the court's going to look at that. But the reality is, what matters is what happens in the room when the document is signed. And and the people there are going to have to testify to that if anything's challenged, and that's more important than I think any medical determination.
Great. Thank you. So just saw one question come in, but now is the time to ask questions if anything came up in what Harry was explaining. Let me see what it says here. Okay. If capacity is at issue, should you document your interpretation of a client's capacity, especially if it's close? And if so, what is the best way to do that?
Okay, the answer is yes. And I think the best way to do that is simply take notes. Certainly if you've had the more factual the notes, the better, that you've discussed the situation with the client, you've asked open-ended questions, they seem to be aware of the of date and time and the world around them, and just take notes about the conversation. People also talk about videotaping document executions. And of course that's a lot easier to do today, since anybody can do it on their smartphone than it might have been in the past. And it's almost like the medical opinion. I think where you know that there's going to be a challenge, and you know that the person is going to has capacity, and it's obvious that it will be obvious if you videotape it, then yeah, I think why not do that? Because then you have that evidence, you've collected that evidence, and you can support your client that way, support their wishes. Where the question is always going to be, if you have to get up in court and present that videotape, is, do you videotape all of your clients? If not, why not? Why do you choose to do it in this case? And the answer, of course, is not that you question their capacity, but you knew that their capacity was going to be questioned by others based on the situation.
Do you have to tell them that they're getting videotaped?
Oh yeah. You would make it obvious that they're being videotaped, and talk to them about that. Ask for their agreement.
Okay. So somebody actually asked that question.
Oh, that was the next question.
Yeah.
Okay.
Is unusual distribution picking one child out of 4 to inherit a house when prior will was to all 4 children equally?
I think they're saying, would you videotape it then? And I think you would be more likely to. I mean, the other issue, the nice thing about a videotape almost, even if it's not so much of an issue for a court of law, having a videotape or some explanation that the client makes to the family, explaining why they're making this decision, may be useful to deter people from challenging a decision or bringing a case.
Okay. Oh, sorry. The other question though was the one child out of 4. If that.
Yeah.
Okay.
Yeah.
All right. So let's. My brother-in-law recently persuaded my husband, who has early-stage dementia related to advanced Parkinson's disease, to file for divorce against my husband's own wishes. We have undone that divorce proceeding now, but do I, as the spouse, have any recourse against my brother-in-law for the $25,000 he has caused us to spend in legal fees?
I don't think so. It sounds unfortunate on many levels, the legal fees being just a piece of that. But it's hard to get some. Yeah, I don't know what you could do on that. Maybe somebody else on the call, if they want to write in, if they have some ideas, we can share them. But I think probably be easier to just move on.
All right, so that is all that I'm seeing. But we do encourage you to continue the conversation. Again, if anything comes up, you can use askharry.info. this is a really great resource. And also, if some of you aren't aware, we now have an Ask Harry podcast series. So Harry talks with other industry experts to answer questions by podcast. Each includes an invited guest answering questions posted online and discussing an estate planning issue on which he or she has special expertise. So be sure to tune in. And we have all the current recordings linked on our website in the resources section called podcasts. It's very easy to use. You just click on it and it'll load right away, so you can listen even right from the website.
Yep.
So that's it for today. Thanks everyone for attending, and we hope that this was useful. If you have any topics that you're particularly interested in, you can use the askharry.info, or you can send an email directly to me, which is bck@margolis.com. So thanks, Harry, and we will have a recording of the presentation for anyone who wasn't able to attend. So please see all our contact information if you need additional follow-up, and hope you enjoy the rest of your day. Thanks.
Yep. Thank you, Beth.
Thanks.
Let me just add one more plug for the askharry.info site. That's a site where I tried to put down everything I know about estate planning, and clearly it's not everything, so people can ask questions and I will answer them. And that's how we keep adding content, by getting those questions and posting the answers anonymously online.
Do we get to talk about your book?
As Beth just referred, I'm finishing up a book on estate planning too, and that should be out in June. And it is called Get Your Ducks in a Row, The Baby Boomer's Guide to Estate Planning.
Great, so we will be sure to let you know about that as well. All right, thank you everyone.
Okay. One more down.
All right, that was good.
Yeah.
Hold on. Close. Let me just do this. Quit that player.